Hello. In this video, you will learn about the AML and KYC regulatory requirements such as enhanced due diligence measures to be performed for high-risk persons. Casinos are required to identify and verify high-risk persons and apply the EDD measures before providing them access to the services or facilities of the casinos. High-risk persons are persons who belong to high-risk jurisdiction or country, which is declared as having weak AML and CFT controls, or is marked as banned country for trading purposes due to corruption. Here are some examples of high-risk category persons or businesses for which enhanced scrutiny is performed. Real estate agents or brokers. Politically exposed persons. Offshore companies. Accountants. Shell companies. Liquor stores. Dealers of precious stones. As per FINTRAC, FinCEN, and other regulatory authorities, there are usually two types of PEP, for which EDD measures are applied. A domestic PEP is a person who currently holds, or has held within the last 5 years, a specific office or position in or on behalf of the federal government, a provincial or territorial government, or a municipal government. Specifically, the person has held the office or position of Governor General, Lieutenant Governor, or Head of Government, Member of the Senate or House of Commons, or Member of a Legislature, Deputy Minister or equivalent rank, Ambassador, or Attaché or Counselor of an Ambassador, Military Officer with a rank of General or above, President of a corporation that is wholly owned directly by Her Majesty in right of Canada or a province, Head of a government agency, Judge of an appellate court in a province, the Federal Court of Appeal, or the Supreme Court of Canada, Leader or President of a political party represented in a legislature, or Mayor. A foreign PEP is a person who holds or has held one of the following offices or positions in or on behalf of a foreign state: Head of State or Head of Government, Head of a government agency, Member of the Executive Council of Government or Member of a Legislature, Military Officer with a rank of General or above, President of a state-owned company or a state-owned bank, Deputy Minister or equivalent rank, Ambassador or Counselor of an Ambassador, Judge of a Supreme Court, Constitutional Court or other court of last resort, or Leader or President of a political party represented in a legislature. The family members and associates of PEP are required to be identified as part of the due diligence process before onboarding or providing services to them. The family members and associates of PEP, once identified, are marked as high risk under the records of the organization or financial institution. Here are the examples of family members and associates of PEP as per FINTRAC. Family members of PEP. If a person is a PEP, some of their family members are considered family members of PEP, as per PCMLTFA. The family members of PEP are as follows: their mother or father, their spouse or common law partner, their biological or adoptive children, the mother or father of their spouse or common law partner, mother-in-law or father-in-law, and the children of their mother or father, siblings. Once it is determined that a person is a family member of a foreign PEP, they remain a family member of a foreign PEP forever, and determination is not required again. Close associate of PEP. A close associate can be a person who is connected to a PEP for personal or business reasons. Examples of relationships that could indicate that someone is a close associate, personal or business, could include, but are not limited to, persons who are the business partners of, or who beneficially own or control, a business with PEP, are in a romantic relationship with a PEP, are involved in financial transactions with a PEP, serve as prominent members of the same political party or union as a PEP, serve as a member of the same board as a PEP, carry out charitable works closely with a PEP, or are listed as joint on a policy where one of the holders may be a PEP. Enhanced due diligence measures to be taken by a casino. as per regulatory requirements, such as those mentioned in the regulatory requirement issued by FINTRAC, FinCEN, OSTRAC, etc. High-risk category customers are required to be identified and marked in records. Enhanced due diligence measures are to be performed for high-risk category persons or clients, such as politically exposed persons, PEPs. The compliance program of the casino includes the requirements of EDD measures for the high-risk persons or clients. Enhanced measures are the additional controls and processes that a casino puts in place to manage and reduce the risks associated with your high-risk clients and business areas. As part of a casino's compliance program, you must develop and apply written policies and procedures for the enhanced measures that you will take for any ML or TF risks you identify as high. Casinos, while performing enhanced measures, take the additional controls and processes that have been put in place to manage and reduce the risks associated with their high-risk clients and business areas. As part of a compliance program, casinos must develop and apply written policies and procedures for the enhanced measures that the casino will take for any ML or TF risks as high. Casinos must apply EDD measures, in addition to the required KYC measures, to manage and mitigate the ML/TF risks arising in the following cases. In cases when there is an available information which suggests there is a high risk of money laundering or terrorist financing. In any business relationship with a client situated in or belonging to or performing transactions from a high-risk third country identified by the European Commission or other relevant regulatory authority. If the casino has determined that a client or potential client is a PEP, or a family member or known close associate of a PEP. In any case where the operator discovers that a client has provided false or stolen identification documentation or information, and the operator proposes to continue to deal with the customer. In any case where a transaction is complex or unusually large in nature, or there's unusual pattern of transactions, or the transactions have no apparent economic or legal purpose. In any other case which, by its nature, can present a higher risk of money laundering or terrorist financing. EDD measures may include obtaining the following information from the client or customer for the purpose of performing the detailed scrutiny and investigation about the customer or client. Occupation or nature of business activities. Purpose of opening the account. Expected origination of funds or destination of funds. Business documents or company documents, such as articles of association, partnership agreement, etc. Expected pattern of activity in the account, the currency, and the expected volume. Other personal details and business relationships the customer maintains. Expected annual sales or turnover. Employment history and expected salary for employed customers. Additional sources of income, if any. Current net worth of the customer. Identification of the beneficial owners of accounts. Annual financial statements for companies or businesses. AML/CFT policies and controls applied by the customers in their company or organization. References from reliable third parties, such as from the banks. Reputational check of the principal officers/senior management of the company, etc. The MLRO regularly monitors the accounts and activities of the high-risk category customers, such as politically exposed persons, PEPs, to ensure that the transactions and activities of the high-risk category customers are matched with their transaction thresholds. Accounts of high-risk category customers need to be monitored without the generation of alert in the system to minimize the risk of occurrence of money laundering risks. In case the transactions and activities are not matched with customers' risk profile and transaction thresholds, then investigation processes must be initiated by the MLRO or AML team in coordination with account opening team or officers. The MLRO must obtain and scrutinize the information and identify the reasons of occurrence of unusual transactions or activity in the customer's account. On the basis of valid justification and evidences, the MLRO or AML team marks the investigation process as closed.